Hello, everybody. My name is Ben Rhodes. I'm the Senior Vice President with CAMS. Today, we have Adam Beaudoin here to talk about the Corporate Transparency Act. This is a new one for us and probably a new one for everybody. Normally, you'll hear us talk a little bit about best practices, municipal regulations, state regulations. Now we're talking about federal regulations. So this is one of the many federal laws we need to become more familiar with. So as a reminder, we are recording this session and it will be posted on the camsmgt.com website under the webinars. There are a number of different webinars that we've recorded over the last several years, and we hope that you will share this information with your board members and let others view them as well. So we will be doing questions throughout the webinar. So if you do have questions, please type that question into the Q&A feature at the bottom of your page, and I will help facilitate those questions as they come up and ask those for Adam. So Adam, thank you for being with us today. I'll let you do a quick introduction of yourself and we'll get it going.
Ben, I really appreciate it and really appreciate CAMS, and hello out there in virtual land to all attendees. I'm really happy to see at least 49 folks want to learn about the Corporate Transparency Act. Of course, when I'm done, you probably wish that you hadn't. I'm Adam Beaudoin from Ward & Smith. We have 5 offices: Asheville, Raleigh, Wilmington, New Bern, and Greenville, about 110 lawyers. And I'm the head of the firm's Community Association Practice Group. We've enjoyed a very great relationship with CAMS for my 22 years of practice here in North Carolina, and happy to be here. And so, as Ben said, I want this to be as interactive as it can be, meaning go ahead and type in your questions, and he'll be the cruise director of that as we go through this. So I'm happy to fire it up and go ahead and get started, Ben, if you're ready for me to.
Let's get it going.
All right. Let me go ahead and share my screen here. It's always fun having to share your screen, and it kind of minimizes things. So then it's like, oh, we have to start the slideshow. So anyhow, let's see if I can get it going here.
Adam, up at the top, there's a little play button.
Yeah, I can't see it because my screen is.
Oh, I'm sorry.
Then there we go. I got it. Okay. There we go. Thank you, Ben. Yeah, sometimes it on the top of the Zoom. All right. So the Corporate Transparency Act and
one more sec, Adam. We're still seeing your other screen. So if you change the display, that'll give you the presenter view.
Okay. So is that my video here?
Nope, that's not the video. Up at the top center of the page, there's generally a little drop down that says display. See if you can switch that display.
Oh, I want this. This is what I want.
There we go.
There we go. Got it, right?
Yep.
That's right. Okay, good. All right. So that's why I went to law school, so I didn't have to be an IT person or even learn software. Yeah, we have people for that. Thank you, Ben. The Corporate Transparency Act, how it impacts community associations. The Corporate Transparency Act has been around for a while, but it hasn't really gone into effect. And so it was part of the National Defense Authorization Act back in 2021, really as a vehicle or a tool to combat money laundering, preventing terrorism, crime, ways for criminals to use what I'd say smaller businesses to do bad stuff. And so it's, if you can imagine, we're getting there. It's going to be effective January 1, 2024, allegedly, but it's taken the federal government almost 3 years to get its act together to put this in place. So what does it mean to you as a community association, or for example, a management company that is a business? It's going to require certain what we call reporting companies, and I'm going to get into that as to what a reporting company is, to file information on the company as well as what they consider to be the beneficial owners. And that information is going to be held in a database with the Federal Crimes Enforcement Network, which is an agency that's been around for a long time. It deals with a lot of insurance fraud, banking fraud, etc. We refer to it as FinCEN, and it's part of the Department of the Treasury. And so the challenge is that the definition of a reporting company and the beneficial owners is fairly robust. We're going to go through that. Now, the only bit of good news in this entire presentation is that it does not cost anything to have to file with the FinCEN system. And so when is it effective? January 1, 2024. Well, the good news is that any company that was created before January 1 of next year, that is 2024, is going to have an entire year to file its initial beneficial owner information report. That's really great news, especially for a law firm like mine that represents thousands of entities that are most likely all going to have to do this report. And when I say entities, I mean for-profits, nonprofits, etc. Now, companies that are created after January 1 or on or after January 1, 2024 will have 30 days to file their initial beneficial ownership report. And so that runs from the date of incorporation in the state of incorporation. There are proposed regs right now that are going to potentially give a break for all of next year and allow 90 days and not ratchet the 30 days up until after January 1, 2025. So just remember, an existing company like CAMS, for example, is going to have time to file. Now, CAMS probably will get an exemption, and I'll explain why. Being part of a larger business network, you may be able to get an exemption. We're going to work through those. But if you are created after the first of the year, you're going to be on a time clock, and there's some civil and criminal penalties involved if you don't do it. We're going to go through those as well. But this is going to apply to developers. It's going to apply to associations. It's going to apply to management companies, law firms, etc. It's across the board. All right. So what companies are going to be considered a reporting company? And so there's really two types of reporting companies, domestic and foreign. Foreign, we'll get to in a minute, but domestic are going to be your regular corporations, limited liability companies, limited liability partnerships, limited, trusts, your business trusts, anything that is going to have to file paperwork with a Secretary of State in any of the 50 states or territories. That's a reporting company. That's at baseline. So if any of you out there, board members, community members, you own your own business, this is going to apply to you also. So the only ones that aren't going to be a statutorily created entity will be a general partnership or maybe a single owner proprietor or a statutory trust. So a lot of your revocable trusts, things of that nature that you might use for estate and tax planning are likely going to have an exemption of the trust itself, which is nice. But as we'll find out later, that may not actually come to fruition if there's some ownership things. So, all right. So I said we talk about the foreign companies. We don't really care about that this much, but I want you to have this information So if it's a foreign company that's registered to do business in the US or on any tribal jurisdiction, you're going to have to do the same thing. You're going to have to register your company as a reporting company. Again, they're after fraud, they're after money laundering. They want to cut down crime and the ability for criminals to fund their operations. All right. So let's talk about the exemptions, because that's what really matters. Generally, there's 23 exemptions, and they're all in really heavily regulated industries. So I'm not going to spend a lot of time reading these off to you, but this entire first page deals with essentially banks and financial institutions, your credit unions, your holding companies. The reason why is that the SEC, the Securities and Exchange Commission, they already require all of this type of reporting to the Treasury and to FinCEN. So it would really be redundant. So they're not going to make any of these types of entities. That doesn't help us for the purposes of today's discussion. Then the next category that you have are these brokerage houses, these financial planners, investment companies, or venture capitalists, your insurance companies. Again, all extremely heavily regulated industries that already have reporting requirements. So no need to make them do it again. The government already knows who the owners are, where they live, what they look like, et cetera, et cetera. The third category here are your financial markets, your pooled investments. And you'll notice down here at number 20 and 21, it says certain types of tax-exempt entities, and then entities as assisting a tax-exempt entity. Now, I find this very comical because nowhere in the regs does it describe what an entity assisting a tax-exempt entity is. And so that's, anyway, as a lawyer, I know they're still working on it, but if they're going to actually roll it out January 1 of 2024, we're going to need a little more shape on that one. I promise that we're going to come back to number 20, because normally when we talk about certain types of tax-exempt entities, you immediately go in your mind, well, our homeowners association, our community association, that's a tax-exempt entity, right, Adam? Well, that's correct. If done properly, it is. It's not a fully tax-exempt entity, but it does carry with it enough tax exemption that it's thought of that way. But we're going to dive into that more. All right. So besides the nonprofit stuff, the other entities that I want to talk about are these large operating companies, because this is where the majority of all companies in the United States are going to be able to find their exemption, the publicly traded ones anyway. And that's a large company that has at least 20 full-time employees and that grosses more than 5 million in receipts and sales. And the government is going to base that on what you filed for your 2022 taxes. And then it'll be every other year. So if your company has more than 20 full-time employees and you grossed more than 5 million in sales or receipts and showed that on your 2022 tax return, you don't need to file a report. You're exempt from this Corporate Transparency Act reporting requirements. And so that's really important for larger companies to know that, to take advantage of that. Number 23 on the list is, which is really, it's really 22, because my first one was not one of the exemptions. It was just a general statement, but it talks about subsidiaries of any exempt entity. And so when you have subsidiaries of any exempt entity, they're also going to be exempt unless, oh, and there we see again, not entities assisting tax exempt entities. So it pops up yet again, there we see this assisting a tax exempt entity. Don't really sure what that is. It's not going to be a homeowners association, but it is very interesting. And then, of course, my number 24, which is the 23rd exemption, that's the catch-all for these inactives. So if the company, you formed it, but you haven't done anything with it, it hasn't made any money, you're going to dissolve it. You're going to be exempt as well. So my takeaway from this, before we get into the HOA piece, if you have a company you're not using that doesn't fall into one of these exemptions, just go ahead and dissolve the thing before the end of the year. It's as good a time as any to do that. And so just a little tidbit there. All right. Tax exempt entities.
Hey, Adam.
Yeah.
Just a quick question.
Sure.
A couple that popped up, but one is they wanted to know how exactly does this apply to homeowners associations, and I think you're going to get into that. So, and then what does the association need to do with regards to the form? Do you have an example of the form, or is that something we can discuss later?
We are going to get to all of that.
Okay.
And so I promise you'll have answers to all those questions. And this is, we're building towards it, right? So what does this have to do with homeowners associations? Every single homeowners association in North Carolina, save maybe a handful, which are called unincorporated associations, is a nonprofit corporation, which falls at baseline as an entity that was created with the Secretary of State, would have to file with the federal government. Okay. Now, the only way that a homeowners association is going to be able to get out from under that is if it is so large, it has 20 employees and is grossing over $5 million in receipts. Okay. And so outside of this other stuff, right? So up until this point, most homeowner associations aren't going to do that. They're not, because they're not going to have the employees. Some of them may have more than 5 million in receipts and sales, but it's only going to be member dues, which isn't going to count, right? So it's a very few large associations are going to be able to fit that bill. So we're going to look under the exemption, which is the tax exempt entity. So what does the government say that is? So any 501c organization, and there's a list from 501c3 all the way to 501c29, or an entity that's exempt under 501a of the tax code, or a political organization, as you see here. So HOAs typically come under the IRS 528 code, okay? They're not a 501c. They're not a 501a. They're not a 527e. You don't really need to worry about the numbers, but what I'm saying is that if you're filing an income tax return that is a 1020 or a 1020 EZ, you're under 528. And I would imagine 100% of CAMS associations are under that. I would guess every management company. There are some rare cases where an HOA can qualify as a 501c4 social welfare organization or a 501c7 social club. I'm going to drill into those a little bit more. I've been doing this 23 years. I've seen one association that meets the standards of a 501c4, and I've seen zero that can meet the criteria for a 501c7. And we're going to talk about that. So as of now, the plan is that every homeowners association is going to have to report.
And Adam, I want to clarify one thing. This is a federal law. You made reference to North Carolina associations. It does affect South Carolina associations too.
Oh, heck yeah. Yeah. Any entity, right? South Carolina, Tennessee, Virginia, Georgia, every single state. This is federal law. And so what I'm saying, my example, Ben, and I appreciate it, right? Because I want to tend to the audience. The point I was making is that in North Carolina, for example, you cannot have unincorporated associations anymore. You used to be able to prior to 1999. And in South Carolina, I don't believe you could ever have them. So my point is that as we try to, I don't want to say weasel around, but as we try to maneuver to try to avoid the reporting on this, and the reason you're going to want to avoid it is when I tell you what you have to report, it's not going to be fun for anybody. It's not going to help you get people on your boards. It is every state, Ben. So yeah, it's federal law. And I was just using North Carolina as an example for that purpose of being incorporated. South Carolina, every association is going to be incorporated. Virginia, every single one's going to be incorporated. Georgia, same thing. Are there any more questions, Ben, before I keep rolling?
Keep going.
All right. So I'm going to explain to you what a 501c4 and a 501c7 are, and then you're going to be able to see why it's really hard for an association to qualify. So a 501c4, the big kicker here is that your amenities are open to the general public. And one of the tenets of homeowner associations in general is that your amenities are what? Your amenities are private, that only the members, their tenants, guests, and invitees can actually use the facilities. A 501c4 type homeowners association is where the homeowner association owns the park, it owns the pool, but they open it up for free to the general public for the good of everyone in that community, not just for the good of the owners who pay to maintain it. And that is generally not something that's very attractive to owners, because you're buying into a community to have exclusivity of amenities and a certain look and feel, and to keep out people that don't contribute and towards the amenities. That's its function. A 501c7 is really like a country club or a yacht club. It's got to be organized for pleasure, recreation, etc., like a dining club. The trouble with a homeowner association is trying to become a 501c7 is you become a member automatically by purchasing a home, not by being someone who likes to play golf. But there may be some homeowners associations that own a golf course where you're required to be a member of the country club, that you might be able to actually apply and get this exemption if you wanted it. Very rare. I'm sure if I was doing this live, I would ask how many associations own a golf course. And I know if we had people in Horry County or Brunswick County, they might raise their hand and say that a few of them do. So this may be something to explore with your attorney. You might be able to get that qualification. So just remember this: unless you have an IRS determination letter that says you're a 501c4 or 501c7, you are not exempt from reporting under this the Corporate Transparency Act. You're going to have to do it. Okay. So now, as Ben teased the question, right, Adam, why does this matter to homeowner associations? Because as of now, unless a new exemption is created for homeowners associations, and I can tell you, CIA National, CAI, Community Association Institute, I'm sure you all know about it. They're trying hard to get HOAs exempt under 528. Okay. And that's, we're going to stay tuned. We have a couple months, and this thing changes every month. There's new regs that come out every month. So fingers crossed. And if that happens, we'll of course let CAMS know so they can send a blast out to everybody and let you all know. But as of now, you got to buckle up and prepare. So who is a beneficial owner of a reporting company? Well, we know all HOAs for the most part are going to be a reporting company. So who are those beneficial owners? Because you're probably scratching your head and saying, well, Adam, no one owns shares in our company. It's a nonprofit. We're just members. Exactly. But look at item number 1 here. Any individual who directly or indirectly exercises substantial control over the reporting company, and this is important, or an individual who owns or controls 25% or more of the ownership interest. The or is the big key here, because if the word or was the word and, then every HOA would be out of it because nobody owns the HOA, right? There's no shares, there's no ownership interest outside of you owning your lot or your unit. But it's under item number 1, the individual who has substantial control over the company that's gonna pull in who has to be reported. So what is substantial control? Substantial control is to direct, determine, or exercise substantial influence over important decisions of the reporting company. That's a mouthful, and it's a huge net. And so the government does give us a list of who automatically is going to be considered someone who exercises substantial control over a reporting company. It's going to be the president, CFO, general counsel, directors, managers, etc. What have I hit on right here? What does every HOA have to have in North and South Carolina? A board of directors and officers. All of those people are deemed to have substantial control. And if you have other officers that maybe aren't traditional, but they're in your bylaws, if they perform a similar function, they control the money, they control the minutes, they control decisions. You could have your architecture review committee members have to be listed as beneficial owners because they make substantial influence and decisions regarding what is and what is not built in your community. Okay. And so we have to be careful. So typically we talk about, and I'm going to come back to the HOAs on this specifically, the ownership interest is going to be stock, bonds, or it might be some type of debt instrument. Could be a promissory note, it could be a trust. But we're not really going to worry about that a whole lot. But it is going to cause a lot of people to want to own less than 25% of businesses going forward. I can tell you that. So for an HOA, as we've already discussed, every director and officer at a minimum is going to be considered a beneficial owner, even though they don't own a single thing in the association. The other thing for management companies to really consider is whether or not the terms of their management agreement are going to give the manager substantial influence over the association. Now, I know CAMS agreement, I didn't draft it, but I've reviewed it and I negotiate it. CAMS does a nice job in theirs of making sure it's clear that all of the decisions are made by the board and that the manager is merely the agent of the board, which is what it's supposed to be. It's an agency relationship. Yes, CAMS is holding the money. Yes, CAMS is doing this and that, but the board is directing who's going to be foreclosed, who's going to, the members are going to elect the board members. The board's going to decide what contracts are get entered into, except in maybe a emergency situation. So, but be careful with that. And so if there is any type of decision-making authority in an officer position of an HOA, you're going to be one of those beneficial owners. It's not great news. Not really happy about that. So, okay, I've already said Bad news, HOAs are reporting companies. Bad news, directors, officers are going to be considered beneficial owners. Now we're going to get to strike number 3 during this baseball postseason. Much like Arizona, who's about to disappear from the playoffs, you're gonna be really upset with me after we go through this. So we already talked about the companies that are created after January 1st, 2024. That is new companies. They're going to have to give information about themselves, their beneficial owners, and their company applicants. Now, you all may not care about the company applicant piece, but I tell you, your management company does and your law firm does, because we're going to have to. Adam Beaudoin's going to have to put his name on there as a lawyer incorporating any new associations. Your management company is likely going to, if they help file the report on an annual basis, they're going to have to, the first year, they're going to have to show up as a company applicant. Okay. And so it's going to be up to 2 individuals who are the company applicant. I'm going to talk about what we have to disclose for the company and what we have to disclose for the beneficial owners coming up. But right now, the company applicants, that is who's actually doing the filing, those are going to be 2 people. So at my law firm, for example, I'm the one who signs the articles forming the entity. I have to provide information on myself, and my paralegal who pushes send to file it, she's going to have to also provide that information to the government. Do we have any questions, Ben, before I go on?
There are a number of questions about the form and who files that form. So you may get into that later, but
we're going to keep on trucking. But what
okay.
I will say is this, that there is no form yet. You cannot even file if you want to, because they haven't opened up the website. But I am going to tell you that it will have to be done electronically on the website, and I'm going to tell you what they're going to need, the information, the data you're going to have to enter, and we're going to talk about who does it. Okay. So we just talked about the companies that were formed after January 1, 2024. The ones that were formed beforehand only have to file information about themselves and the beneficial owners. Okay. So that's good news. So that means there's no applicant that has to file and disclose who they are. So for existing companies under management, the management company or the law firm can file it without having to disclose their information. That's a good thing, because it's a headache and it's just a pain. It's going to be a lot of filing. So what does that mean, Adam? What does the company, in this case, the HOA, have to report about itself? Its legal name, any trade names that it may have, current street address, and that's important, street address of its principal place of business in the United States, and what state it was incorporated in, and its taxpayer ID number. And if there's any of you out there in virtual land that are asking what a taxpayer ID number is, you have bigger problems than the Corporate Transparency Act, okay? It means you haven't been filing your taxes. But if you're managed by CAMS, you have, so you don't have any problems, okay? So those are pretty benign, minus the tax ID number, because all of that can really be found already, is public information that can be found about the corporation, minus the tax ID number. But here we go, and we'll do, a little bit of a drum roll, right? This is the 3rd strike. What must be reported about the beneficial owners and the company applicants? Their name, date of birth, and their residential street address, and the identification number from a current driver's license or state issued ID card that has a photo on it, a passport, or a non-expired passport by a foreign government, A military ID issued by the Department of Defense does not work. And you have to send a copy of that document with it. You're going to have to upload it. And so I have a lot of heartburn about this because the government has a system that's not even set up to take this information yet. They're working on it. What if someone gets a hold of it? Think of all the personal information, right, that they're going to get, minus your social security number. But this means that for every board member that gets elected or every officer, they're going to have to disclose their date of birth, where they live, and provide a valid state-issued ID or government passport, U.S. passport. That's a lot of information that you don't have to give right now to serve on a board. And I think that a lot of folks are not going to want this information to be shared with the federal government and will decide not to serve on boards as a result of this. I could be wrong. So I'm going to stop right there if there's any questions, because I know that's a lot.
So a couple of questions. Let me start at the bottom first because it was relevant to, well, how often does this need to be filed?
How often does it need to be filed? So there'll be an initial filing, and then there's a duty, and we're gonna talk more about it. But anytime that the officers change, a new filing will have to be made every single time. So it's not necessarily an annual filing for every company, right? Because if the same directors and officers, but for the nature of an HOA, where the board has an election every year and a handful, you're going to have to report every year. And you're only going to have 30 days to do it from the date of the change. And so, yeah.
Okay. So my HOA has a master as well as an individual association for each neighborhood. Is this law more for the master association or all HOAs?
All of them right now. Every single one. So unless you can find an exemption, you have to file. And what I would say is the law really was never intended to apply to HOAs. But it does, unless we can get it clear. Because I've never heard of a story of a terrorist group using an HOA to launder money. But it could happen. Who knows?
I don't know if now would be the time to plug your LAC and your your national lobbying organization, but do you want to speak to that?
Yeah, I think that if you want to reach out to anyone, Community Association Institute Legislative Action Committee at the national level is who you can reach out to. If you want to make a donation, if you want to provide some support, that's who's working in Washington to try to get exemptions for HOAs, because it's clear the government wanted to keep tax exempt entities out, but it forgot about an entire segment, community associations, which quite honestly probably make up the largest number of nonprofits in the United States. But people don't think of them as nonprofits. They think of them as HOAs, right? Or our folks out west would say HOAs.
Okay, a couple more questions. You had commented earlier about who needed to be involved or at least named, but what about committees of the board? If they have a maintenance committee, a finance committee, a landscape committee, where committees are not board members?
Right. So it's about substantial control. So Ben, what you just said was committees of the board. The answer is yes on committees of the board. And I'm going to come back to that. But any other committee, like a finance committee, a landscaping committee, a maintenance committee, committees that don't have authority to make the ultimate decision, but make recommendations to the board, those committee members are not going to be considered beneficial owners. But if you have a committee of the board, for example, you decide to create an executive committee that has, let's say, 2 board members on it and 1 non-board member. That 1 non-board member is now a beneficial owner because that committee of the board has some of the authority of the board, which is why I was saying, if you have an independent architecture review committee or what we call control committee that acts independently of the board, those members of your architecture review or control committee are likely going to also have to be listed as beneficial owners because they're making the decision on what you can and can't build.
Okay. Our HOA was created many years ago. Who is it incorporated with? And yeah, is it the Secretary of State or the feds?
It would be the state, whatever state you're in, at the Secretary of State. So in this case, we've got what, South Carolina, North Carolina folks on?
Yep.
So that's going to be the Secretary of State. And if CAMS, if you're managing them, you've got a copy of their articles, you can provide it to them.
Yep.
But yeah, there's no homeowner association created by the federal government. I mean, heck, they don't even think about us because they didn't give us an exemption yet, right? Because they don't even know we need one.
But yes, if you do need your articles of incorporation, your manager can help get that for you. So then the developer or attorney is responsible for filing the form. So I'd say that would be the initial form.
Yes, Ben, you're correct. That the initial form with developer appointed board members is going to be, and developer appointed architectural committee members, they're going to be responsible for filing it.
So can you specify the place of business? A lot of associations don't necessarily have a place of business. Would that be the management company's place of business or somewhere within the community?
So in South Carolina and North Carolina, you have 2 addresses, a principal office address and a registered office address. Some of you may not have both, but you're supposed to have both. But older ones, you just need a registered office. So the principal place of business is going to be that address listed with the Secretary of State. So it could be if you have a clubhouse. If not, it's going to be the registered agent address, which might be your attorney. It might be your management company. That's what will be listed there for your business address.
Okay. And in many cases, the registered agent is CAMS, so we can certainly help you with that address. Let's see.
But keep in mind, one thing to go back, Ben, on one question is, for new entities that are formed after January 1, the developer is going to be responsible for doing that because they form them. But for existing associations that exist now, the association itself is responsible for filing. Even if it's under developer control, it's that board of directors, it's their responsibility to do it, whether elected or appointed, because the association is the one that's on the hook for the penalties, as are the board members. And there's potential jail time associated with it that we're getting to.
So this question's come up, is the form a form for the individual or a form for the association?
The association is the reporting company, and it must list those beneficial owners when it goes to enter the data. And like I said, it's going to be a portal, right? There's not going to be any way, there's no paper filing. It's a portal that you will sign up. Every company will get their own individual ID when they sign up the first time to log into the system to upfeed the information.
Okay, and several questions have come in about who's going to file the form. Will CAMS do it for us? And so I'll just say this is very new. This is almost as new to us as it is new to you, hearing this for the first time. So we're still learning about the Corporate Transparency Act, and our fingers are crossed that they're going to exclude associations from this entire process. So we're hoping for that too. But there will be some more information coming out about how it is filed and if CAMS can file on your behalf. But we'll wait for that information to be released.
Yeah, and just to let everybody, to back up what Ben's saying, the final regulations didn't even come out until September 4th of 2023. That's how new this is. It's a little more than a month old. And so we're going to be doing other presentations. I'm happy to, we have a good relationship with CAMS. We're going to be giving them information as we get it, as we update things, and as the portal becomes active. Number one, we are hopeful that we can get HOAs out from under this so we don't have to do it at all. Number two, if we have to, we're going to be able to come back to you with more information after the first of the year to help streamline the process. My guess is they're likely going to push it because it's a huge undertaking. They've been pushing it for 3 years. And so we want to be ready because this is the first time they said they're going to do the green light, and they've given a date for that, which is the 1st of 2024. But stay tuned. It is very new and it is changing, but we wanted you to know about it because it is something that could impact you. And if you don't catch it, there are significant civil fines and potential jail time. That's why we want everyone to know about it. That's why when Ben asked me, hey, will you talk on something? I said, I got one for you. You ever heard of this? And most HOAs haven't. I mean, the North Carolina Bar Association did its very first CLE on this last week. That's how new this is. It's new to lawyers too. And so I just happen to be one of those lawyers that's a nerd about this stuff, and I pay attention to it. And so that's why I know about it. And I want to kind of spread the word. So I'm not trying to set off alarms. I just want you to be prepared.
Well, so 2 questions before I ask the question about the fines and penalties that I think you're going to get into. 2 questions that talk about what if we can't get a board member, and what if an association, just all board members resign because of this, then what happens?
Yeah, I'm going to wait till the very end to talk about that, because that's kind of the chicken little sky is falling type thing, and the nuclear option, if you will. We'll talk about that at the end. That'll be our final crescendo.
Okay. So,
all right. So as we've talked about, the information is going to be electronically reported, and there's 30 days to any changes in beneficial ownership or corrections. And that's an ongoing, continuing duty. Okay. That's going to happen no matter what. Okay. So the good news is that this information is not publicly available. It's only for U.S. law enforcement and some non-U.S. law enforcement agencies, and that's a federal agency in another country. Okay. And only with court approval. So this information is supposed to be highly confidential, allegedly, right? Until we get hacked. But I'm a lawyer, so the glass is always half empty. All right, here are the civil and criminal penalties. So reporting violations, it's $500 per day, and the criminal side of it could be up to $10,000 and or 2 years in prison. And so I'm going to get into like willful reporting, which basically is you knew you had to do it and you didn't do it. Okay. That's what they consider willful reporting. And it's a federal law. So you're deemed to have knowledge of it. Now, to get into the criminal, it has to be that you deliberately didn't do it because you're trying to defraud the government, not just because you don't want to do it. So most HOAs are not going to have to worry about the criminal aspect. They would just have to worry about the civil penalties, which is good because we don't want our board members going to jail. Now, if, excuse me, if there's unauthorized use or disclosure of this information, if someone were to steal it, use it inappropriately, as you see, the penalty is $250,000 and 5 years in jail. It goes up. So I'm sorry. So just be aware of that stuff. You guys should be thinking about the civil and the 500 per day. The good news is if they're going to give you kind of a grace period of 90 days if you find there's an inaccuracy. So if you don't know you're supposed to do it, they're not going to punish you. I think most HOAs are going to be around that.
Okay.
All right. So I will now answer the big questions, right? Those big questions. And so I finished with a little bit of time to spare, Ben. So
Did good.
all right. So the first question was, what if we can't get enough board members to serve? So that question presumes that you have some, but not all. Well, the answer is you do the best you can as long as you have a majority of the board. So if you're supposed to have 5 board members and you can only get 3, you can still carry out business as long as all 3 agree. But my advice to you would be to try to find 2 other board members or amend your governing documents to reduce it down to 3. Okay. These are problems that we have now without the Corporate Transparency Act, by the way, of boards not having enough people that want to serve. The nuclear option, or no one being willing to serve, it makes me kind of chuckle, because ultimately what's going to happen is if you have a board of directors that all resigns and no one's willing to stand up, then every single one of those board members that resigned probably breached their fiduciary duty to the company because they resigned knowing no one was there to fill their shoes. So what happens to a homeowners association that doesn't have a board of directors? It can't enter contracts. It can't collect dues. It can't buy insurance. It can't maintain its property. It can't do anything. And so if your board leaves you in the lurch because they don't want to report, every single one of those people is probably guilty of breaching their fiduciary duty of loyalty to the association, because they have an obligation to act with good faith, due care, and in the best interest of the association, not in the best interest of themselves. So those of you that are on the board, when this thing comes about, you're kind of stuck. But I do think it's going to be a bar to having people want to serve. But I caution anybody that drops off without a contingency plan. Because what if your association has a stormwater facility that needs to be maintained and it's not? The state's going to come in and they're going to start to fine the individual homeowners in the community if there's no board. And so that could be $500 a day too. That's under a different law, not this law. But my point is, not really having a board is not really an option if you have assets to maintain and insurance policies you need to have. Now, let's say you're an association that doesn't own anything. You don't have any insurance. All you have is collect dues to enforce some covenant violations. Probably nothing will happen to you. But if you have amenities and things that need to be maintained and insured, it's not going to be an option for your board just to give up because they don't want to tell folks in the federal government how old they are or send a picture of what they look like. I know that's not great. It doesn't make anybody feel great. But here's the thing. You have a duty to help the association get its jobs done, which are laid out in the governing documents. Your management company, you can ask Ben, if there's not a board of directors, they're not going to make the decisions. That's not their place. They don't want to do that. That's not what the contract says for them to do. They can't run it for you without you. You have to be there.
Yep. So couple things just to maybe refresh. Can you offer the definition of the beneficial owner? What is the effective date of the law? And then who is the federal agency that's enforcing?
So it's the criminal division of the U.S. Department of the Treasury. That's who's going to enforce it. Okay. The Financial Crimes Division, that's who will enforce it from the federal government side. It's effective January 1, 2024. That's when it's effective, and that's when they say the portal will open. For the purposes of who are the beneficial owners are going to be the top officers, directors, committee members, anybody who exercises substantial control over the entity itself. So in the context of an HOA, it's going to be absolutely 100% your board of directors and 100% your officers. It may be your ARC, your ACC, it may be some committees, but it will be 100% your board and officers. The other way to be a beneficial owner is if you own 25% or more equity or debt servicing in that particular company. So if you own an LLC with your siblings and you each own 25%, but your dad doesn't own anything, but he runs it and manages it, well, all 5 of you are going to have to report as beneficial owners because he's controlling it and each of you is a beneficiary of 25%. And so that's who's going to have to report. But in the HOA context, there are no owners of an HOA. So it'll be the board and the officers for sure.
So would the association liability insurance protect the board members in case of a claim?
No, because it's a failure to comply with a federal law, which would be considered willful misconduct. And therefore, your director and officer liability insurance isn't going to protect you for failing to follow the law.
Okay. Who can they contact in legislature, in the state, or sponsoring personnel to impact change to the regulations to help exempt HOAs?
It would be your senators and your U.S. congressmen, in the House and in the Senate. That's who you would need to get up with. As I said, the best place to go is Community Association Institute at the National. Go to cai.com and pull up the LAC, the Legislative Action Committee. And there's you can contact, like Phoebe Nesseth is one of the people on there. There's a couple, Don Bauman, that you can contact, and they can give you some information on what they're doing and tell you which members of Congress and the Senate are the best ones to.
Yeah, they are actually doing an advocacy day, November 2nd, so coming up in a couple of weeks, where they're helping coordinate with different legislatures or legislators in the Capitol. So if you're interested, that information is caionline.com, I believe is the website, but they certainly would welcome your attendance. Got a couple of minutes left. So can existing board, after someone resigns, appoint someone to fill until the next term? So
yes, 100%. And please do so. Absolutely. Yes. And if you read, so what I'll say is this, is in North Carolina and South Carolina, unless your documents say otherwise, the board would actually appoint the director to fill the remaining portion of that resigned director's or that deceased director's term. So if it's a 3-year term and they resign in year 1, you're going to fill it for 2 years. I do see some association documents that say, oh, well, the board can fill it till the next annual meeting of the members, but the board absolutely has the power to fill it in the event of death or resignation. If the members remove a board member, then only the members have the right to fill that vacancy because they voted to remove that board member. So there's a little bit of a distinction. But you better file within 30 days of putting in that new director.
Yep. So I'm scared to ask this last question, but and the purpose of this presentation is not to make all of our board members resign from their duties on the board. So we value you board members, and we hope you will stay in your roles. But the question is, today, there is no penalty to resign from the board if I resign before 1/1/24.
No.
Am I still exposed to these potential liabilities?
Yes. Yes. The liabilities to resigning and leaving your community in the lurch exist whether or not this law exists or not. So just know this. As a board member, you have a duty to the association. You don't have a duty to the other board members. You don't have a duty to the members necessarily from a fiduciary standpoint. You have a fiduciary duty to the company. So you cannot leave the company in a place where it cannot function. That's where the liability springs from, not the failure to do these laws, to follow the registration under the federal law. It's about not having a plan of succession for someone else to come and take over. And that exists whether this law did or not. Because I get that question a lot. It's, Adam, I don't want to be on the board anymore. I just want to quit. What can we do? Can we dissolve our community? What can we do? We don't want this anymore. Unfortunately, what I would tell you is if you don't want to be on the board anymore, sell your house in the community and move somewhere else, because then you're no longer able to serve on the board. You're no longer qualified, likely to be on that board. But you can't just give up. And I'm not saying that you should, because you got on the board for a reason, but you can't just give up if you know no one else is going to fill those chairs. If you have someone else that you know wants to do it, then by all means resign, get off that board, let somebody else do it. But if nobody's going to do it and you're the only one that can do it or willing to do it, you're kind of stuck until you find somebody to replace you.
Okay, well, we are a few minutes over. Adam, I want to thank you for your time. Thank you for scaring us.
Well,
Thank you
it's
for
a
being a
Halloween
nerd.
season.
Right.
Halloween season, baby, you know.
So, but several comments on asking for this presentation and the slides. So we are recording this and it will be posted on the CAMS mgt.com website. You can find it under webinars. It will probably be posted probably by Monday if you want to download that and share it with your fellow board members. So again, reminder, this is new and we are still hopeful that there will be changes. So, as information comes out, we will let you know. So don't everyone, January 1st, just run to the website and try and apply, because we may not have to. So, but we're going to continue to get information and share it as it comes. So, Adam, any parting words of wisdom?
One thing, I'll send you, Ben, a copy of the PowerPoint so you can have the physical PowerPoint as well. But my parting words of wisdom are this: don't panic, as Ben said. We're here. CAMS is here. We're going to keep supplementing this. CAI is going to supplement it. We're going to let you know as the law evolves. And just, if you want to reach out to your legislators, do so. But do not panic. This is meant to be informational about something that's coming down the pike. We're hopeful something can change, but if not, better to be prepared and know about it than just like a House Bill 542 that hasn't come to fruition yet. Hopefully it won't, but it's good that we know about it and pay attention to it, because it just makes us stronger in the industry.
Okay. Well, thank you very much. And until next time.
Thanks, Ben. See y'all.
Okay. We'll see you.